from Emory University, and up in Atlanta, a very prestigious law school that has an outstanding estate planning program. Geoff graduated there. He started Family First Firm in 2009. And it's kind of fun thinking back on those days, Geoff. I remember one of your first offices when we met, and it was you and 1.5 other people.
Yep.
And in 2021, he was recognized as one of the fastest growing law firms in the country. And Geoff, you'll have to say what your current staffing is, but I know it has grown exponentially, and it's because you guys do a really, really great job, very conscientious, and we are just honored and privileged to be able to say we are one of your clients. And I thank you again for tonight, taking time out of your busy schedule to spend a few minutes with us. I'm going to stop sharing my screen, Geoff, and if you have anything to share, you would be welcome to do so.
Perfect. Let me get that sorted here. I think it's probably going to have to ask for permission. So let's get
a conference now?
This is being qualifying for Medicaid and veterans benefits. And this is being sponsored by the Florida Conference for seniors.
Can you please move yourself? And
Yeah,
I'm going to try
Dr.
to.
Bryant, we would ask you to mute your computer, and we would thank you for that.
Wonderful. We'll get going here. Yeah, as Phil said, my name is Geoff Hoatson, and I'm the founder and owner at the Family First Firm. Before we get into this presentation, just a few kind of, we could call them some ground rules, things that I think are important. Definitely try to get something out of this. I hope you keep a paper and a pencil handy so you can write stuff down, take notes, because there's going to be a decent amount of information, and the stuff that's important to you may not be important to somebody else and vice versa. So, if you want to really come away with some takeaways, make sure that you're taking notes, because if you're like me, I'll think something's really important, then I'll hear something else, and then poof, it's gone. And then I'd really encourage you to do something with the knowledge. If you feel like there's a solution that might solve a problem that you have, whether you hire us or somebody in our space, I would really encourage you to actually do something with the things that you learn. Knowledge without application is really wasted. And so, it's just important to be able to put yourselves, your loved ones in the best situation possible. So let's hop into it here. This is myself. That up in the top right corner here is my wife and 2 daughters. My daughters both go to Fleece currently. And you can see down here, there's 2 pictures of my grandfather. This was my dad's dad. He ended up getting the Silver Star and the Purple Heart in World War II. And ultimately, he's the reason that I moved into elder law. We are now a team of, I say I believe because we add people left and right all the time, but I think it's 34 people now in terms of full-time employees I have here at the law firm. And we're continuing to grow very rapidly. All right. So let's talk about really what I am, what this is. This is kind of a very verbose way of saying that really I focus on the unique legal issues that seniors face. So, everybody kind of faces different sorts of legal issues at different times in their lives. But as we start to get older, those issues kind of start to compound and become a little more relevant to people that are getting on in their years. So, all these things you can see written down here, these things may apply to everybody, but in total, they're very often going to apply to seniors. So our goal is to help make sure that seniors are getting the care that they need if they're unable to provide care for themselves, and then ultimately creating plans that are unique and tailored to your unique situations. So whenever I'm putting together estate plans, I'll put together 10, and not 2 of them are anywhere near similar to each other, because everybody's unique. Everybody has different family situations, everybody has different marital situations and the like. And so, we really try to listen and ultimately accomplish our clients' goals. So Phil already touched on these a little bit. I'm going to try to breeze through it because we've got about a 2-hour presentation here. I'm kidding. I'm sure I heard a collective gasp if everybody wasn't muted. No, I'm going to try to breeze right through this at maybe about 20 minutes or so, and keep it short and sweet. while hitting the relevant things. The first document is a durable power of attorney. This basically gives somebody else the ability to make legal or financial decisions on your behalf. There's a few things here that are important to note. That back in October of 2011, they changed the laws here in Florida about the way that you can give what the Florida statute now defines as superpowers or special powers to your agent. So these are things like gifting your money, accessing bank accounts, retirement accounts, those sorts of things. Our legislature here in the state didn't want people signing a 13-page document at the end and not knowing what was in it. So they said, hey, if you're going to give somebody these powers, we want to see you actually initialing each of those powers. That was back in 2011. Sadly, we see attorneys doing this stuff all the time that are not in compliance, attorneys not doing stuff in compliance with this now 11-year-old amendment to our laws. One thing you'll note as well, down here it says letter N is not sufficient. So oftentimes we'll see people going on the internet and downloading a power of attorney form that's, I'm going to be honest with you, they're worth what you're paying for it, and they're free. So that should give you some indication what they're worth. But it'll have a number of powers listed, and then at the bottom, A, B, C, D, E, all the way through M, and then the bottom one is N, and it says initial here for all the above. And so people just initial that one, but it doesn't work because you have to initial each individual power. That's what the statute said. It doesn't give you any workarounds or anything like that. Even if you do initial them right, they're still woefully lacking in the needed or required language. Some people like to choose co-agents. Maybe they say, oh, I want my 2 children to make decisions for me. Hey, that's great. What we run into though is people will oftentimes say, I want them to make decisions together. And that becomes a real challenge because if they don't agree, then they're going and hiring lawyers and fighting in front of judges. So what I normally recommend is name one, followed by an alternate, as many alternates as you want and so on. But if you do decide to name 2 together, I recommend you do not use unanimous decision making. You can see that down here at the bottom. You give them the ability to act independently. Just as a note on that, a lot of financial institutions won't even accept a power of attorney that requires 2 signatures because they know the likelihood that they'll mess it up is so high that they'll say, you know what, we're not accepting this. We're not going to put these powers of attorney on your account because chances are some teller will take 1 signature, they'll cash that check, and then they're on the hook for the whole thing. So something to note there. The next document is, there's a couple of them. These are really about healthcare decisions. The last one was all about legal and financial types of things. This is about when you can't make medical decisions for yourself. So the first document is that healthcare surrogate. You think of it as a medical power of attorney. In fact, in a lot of other states, that's actually what it's called. But Florida likes to be unique. And they've changed the names on lots of things, and they've changed the name on this document to a healthcare surrogate. As long as you have the ability to make decisions for yourself, you're going to make them. Once you can't, then they turn to that healthcare surrogate and say, okay, what do we do now? So you don't have to worry about this person overruling your decisions. As long as you can make them, you're going to make them. The second document is really 2 documents here, which is instructions to that first person. That's your living will and a DNR. Now, something I think is important is a lot of people confuse that term living will with some of the other things that we do. Unfortunately, the terms of art in this area are kind of similar in some cases and make it kind of confusing. So people have heard of last will and testaments, and they've heard of living trusts. And so they talk about living wills, thinking it's about how they give their things away. And unfortunately, that's not what that document is. A living will is where you tell your loved ones what you want to have happen if you're on life support. It's the scary sounding pull the plug document. Either you want to be on life support or you don't want to be on artificial life support. And the beautiful thing about that document is it takes away the decision from your kids or your loved ones, whoever that would be. So instead of them having to think, what are we doing? Are we doing the right thing? Is this what he or she would have wanted? You get to tell them, hey, this is what, if I ever end up in that situation, these are the decisions that I want made. And it's a lot of freedom. It provides a lot of, I guess I'll say just clarity for them in a time when things can be pretty murky and pretty scary. The DNR is a different document. People oftentimes confuse those. The DNR basically says if you have died, meaning your heart stops, you do not want to be resuscitated using, CPR or the defibrillators or anything like that. They're different documents, kind of similar, but they're not the same. The living will assumes that you're on artificial life support. A machine is breathing for you, feeding you, that kind of stuff, and you can be removed from that. I always talk about the Terry Schiavo case. If she had had one of these documents, you never would have heard her name, because her parents wouldn't have been in court fighting about this. They would have just looked at the document and said, okay, we know what she wants. This is what we're going to do. So then we get to, the more traditional stuff that people think of when they think of estate planners. How do you leave your things to your loved ones after you pass away? Those other documents we went through previously, those are called advanced directives. And everybody, whether you're 18 or 108, you need those documents. Every single person does. Because let's say you have someone on this call has a child who's 18, 19 years old and at college. If that child gets in an accident or something happens and people need to make decisions for that child, you don't have the right, even though you're their parent, because they're legal adults. So those advanced directives are incredibly important for every single person to have. But then we get to this stuff, the estate planning. So when you pass away, how do you transfer your things to your loved ones, or to charities or religious institutions like the Florida Conference or any of the other places you may want your things to go? And a lot of people are familiar with the concept of a last will and testament. What a lot of people don't realize is that last will and testaments are basically tickets to probate court. It doesn't mean they're bad. It just means that you're going to go through probate if you have a last will and testament. The last will and testament is a set of instructions to the probate judge. Now, probate is, it's a court, has a judge, and they oversee the distribution of your estate. If you don't have a will, the Florida statutes are going to decide where your things go. If you do have a will, then your will tell that judge where the things are supposed to go. So a question that we get a lot, and well, before I jump into that question, I just want to make it clear. Probate normally takes about anywhere from 8 to 12 months here in the state of Florida. So, it can be a lengthy process in order to get those things from your loved ones, from yourself to your loved ones. And of course, this is after you've passed away. So you won't be involved with it, but your kids or surviving spouse will be there to kind of have to pick up those pieces. Now, if you have children who you think would fight, or you can't trust any of them, or you're worried that there may be like some shenanigans, you may actually want them to go through a probate process. That way that there's a judge who will oversee and will hold everybody accountable to do what you want them to do. A question we get a lot is, hey, I'm married, do I need a will? The answer is you're married right now. There's easily a situation where something could happen to you and your spouse together. Or where we see things most common is if you have children from a previous relationship. Our statutes are pretty interesting in how they deal with that. And if you had children from a previous relationship, maybe you get married later in life for companionship, and you don't update your will, you could end up in a situation where your spouse is getting more than you intend them to, or not as much as you'd like them to. So, I've had people who have children who they have no relationships with, and they wouldn't want their children to get anything. But under our statutes, without a will, their child would be getting half of everything, and vice versa. Maybe they want their things to go to their children, but everything or half of everything is going to their second or third spouse. So, what I normally tell people is I can't sit here and tell you you need a will. But what I can tell you is you need to talk to an attorney who can sort through your personal, facts and figure out whether you do or not. Sometimes I tell people, hey, save your money. Don't hire me for this because there's not a lot of benefit. But that's that's a very specific situation. And more often than not, people do need these documents in order to accomplish their wishes. So then we get to kind of some of the more, I guess I'll say, beneficial sorts of documents. I use that word not as to say that last wills and testaments aren't beneficial, but there's just more benefits, value, whatever that word is you want to use. When you talk about things like trusts, we have two different types of trusts that are really the foundation of a lot of our plans here at the Family First firm. The first is the Probate Protection Trust. This is a pretty common type of trust. The goal of this trust is to keep things out of probate and make things very simple for your loved ones after you pass away. doesn't really provide you any sort of protection or benefits, but it makes things, it's a gift to your family, if you think of it that way. When we get over to the Family Fortress Trust, that gift still has all the benefits, of the probate protection trust, but the Family Fortress is really designed to protect what you have in the event that you end up in a long-term care facility paying anywhere from $9,000 to $11,000 a month. If you end up with extreme medical bills, if you end up getting taken advantage of, like my grandparents did by their next door neighbor, who came over asking for money for groceries every single day, and my grandparents didn't. They both had some cognitive issues, and so they wrote checks every single day to these people until my mom saw a bank statement and finally figured out what was going on. Ultimately, though, the Family Fortress Trust protects everything that you put in there. You still have ways of modifying it, getting access to what's in there, but it's beautiful because it protects everything for you. So if you ever need benefits or anything like that, it's there. If you ever get sued, it's protected. And then ultimately, the chances of preserving those assets for your loved ones is substantially higher than if you go any other route. Those are just two of the many, many different types of trusts that exist out there. I will say that for our clients, probably I would say between 95 to 98% of them, this is all, one of these is what they choose for our trust clients. We do have some people that have some more complicated circumstances, people with substantial amounts of money that are worried about things like estate taxes or life insurance inclusion in their estate and stuff like that, but it's not common. So let's talk about long-term care. We were talking about Medicaid and that sort of thing, and let's just kind of dive into what the options are when you're looking to pay for long-term care. I told you it can run on average between $8,000 to $9,000, all the way up to $11,000 on the top end in a nursing facility. So you can try to do it all at home. We see lots of people do that, and it works for a bit. What I always tell people is when you have someone providing 24-hour round-the-clock care to your loved one, they're doing it in shifts. To try to do that on your own is an incredible undertaking, and people burn out pretty quickly. Medicare will pay some rehab. So if you fall, you're admitted to a hospital for 3 overnights, and then you get discharged out to a rehab / long-term care facility. They'll pay for rehab as long as you're getting better. They'll pay for the first 20 days entirely. From day 21 up to 100, they will pay with a copay. They'll pay 80%, you'll pay 20%. Your 20% copay normally works out to around $140 to $160 a day. So it's still, $4,000 to maybe $6,000 a month. But if you stop progressing, because remember, rehab is improvement. So if you stop progressing on day 18, well, they cut off. They don't pay anymore. They're not going to pay you to stay there long term and just stay there. They're paying to try to get you out of there. There's supplement policies. They don't really provide a whole lot. They may pay some of the copays that you have. So on that day 21 up to 100, that 20% that you may owe, this, Medicare supplement policies will oftentimes pay for that. Long-term care insurance is probably the best option if you can afford it. It's gotten extremely expensive over the years, and you have to qualify from a medical perspective too. That's one of the struggles with it, is that a lot of people don't think about this stuff until they're getting to the age where they might need it. And at that point, it's too late to get it. So it becomes a little bit of a challenge. Just paying privately, if you got the money, sometimes we have people coming in, they got, multiple millions of dollars. I tell them, I think you probably just need to pay for it. You can pay for 10 years of this care and still leave millions to your family. I think it's, probably okay to do that. And then the last one is government benefits. That has kind of a negative connotation to some people, but really what we're talking about is Medicaid. And what I always like to remind people is if you've ever worked, you've paid into Medicaid every single paycheck that you've ever earned. And, people think, oh, I don't want to, this is probably your only chance to ever, use some of the benefit which you paid for, in a lot of cases, decades. So it's just a different way to think about, this benefit out there that could be really helpful for you and your family, especially if it's the difference between losing and spending everything in a nursing home or preserving a legacy for your family. A benefit that you paid in for might make a lot of sense. So, there's been an advancement in medical, Medicaid, I guess also just say medicine in our society, which is causing people to live longer. And where, people used to not be as worried about outliving their money. It's happening more and more frequently these days. So if that's something that you've been concerned about, that's where some of the options that we have can be pretty helpful. Basically, what we try to do for our clients are three things. Make sure that our clients have the best quality of care for as long as possible. If, let's say, you're in here to talk about your dad, because your dad's in a nursing home, you want your dad to make sure that he has the best care. We want to make sure your dad has the best care. That's priority number one. We want to keep him safe in a good place where he's going to get taken care of. I mean, we don't want someone, end up with bunches of bed sores and stuff like that. We see it and it's horrible. So the goal is to avoid that at all costs. Secondly, then, if that person is married, let's make sure that their spouse in the home is going to be taken care of. We don't want people going destitute to pay for their loved one in a nursing home. That doesn't make sense because we know what the end result of a nursing home stay is, right? Nobody makes it out of there, being in long-term care and, just getting worse and worse and worse. You don't end up leaving there and coming back home and everything's hunky-dory again. Once you've admitted long-term care, generally it's a downward slope that ends in the demise of a person who was in the nursing home. It's sobering, it's sad, but it's the truth. And it's something you have to realize because, we see people regularly say, I'll spend every dollar to take care of my wife, in the nursing home. I love to tell them you don't have to. It's admirable that you want to, but you don't have to. And think about it. Your spouse is going to pass away and then what? You're broke. What are you going to do? You still have to live, have a roof over your head, gas in the car, food on the table. How do you do that if you're spending every dime you have to a nursing home? So the second thing is to make sure that spouse at home is doing all right. And then lastly, if we can leave something to your loved ones, great. Let's do that too. Now, we'll get into Medicaid in a second, but we did add some slides here because I wanted to make sure we're talking about veterans benefits and specifically the aid and attendance benefit. Basically, there's 4 tests that you need to meet in order to qualify. The first one is related to your service. So you have to have served at least 90 consecutive days of active duty. So this isn't like reservist type stuff or anything like that, because generally you don't serve for 90 consecutive days of active duty. One of those 90 days, at least one, has to be during the time that we were declared at war. And you can't have been dishonorably discharged. So these are the dates for those wars. And if one of your dates of service falls into those windows, then you're on the right path to being able to get eligible here. One thing to point out though is that if your dates of service are not in those windows, there's nothing anybody can do. You are not eligible for this benefit. End of story. We had a guy who came to us. He had enlisted. It was like January 2 of 1947. So 2 days after the cutoff for World War II. And I think he discharged in April of 1950. So about a month or two before the Korean War started. Nothing you can do. He just had to, the VA says too bad, so sad, you don't get it. Now, there are some income and asset limits. I'll be candid with you. Explaining how the income limit works is a little confusing. I'm going to try to keep it extremely high level. Basically, the VA wants to see you spending all of your monthly income on medical expenses in order to give you their maximum benefit amount. That's just the easiest way to think of it. If you're spending all of your money, they'll give you the maximum amount. For every dollar you have left over after paying a medical expense, they reduce your benefit dollar for dollar. So, if you have $3,000 a month coming in, you're spending $2,000 on medical care, your benefits would be reduced by $1,000 because that's what you had left over. However, as far as your net worth, they have a limit of $138,489 that you can have between you and your spouse, or if it's just you, that you can have by yourself and still get eligible for this benefit. If you have assets or income in excess of the limit, there are ways that we can get you eligible for it still. I'll be candid with you, it's not as easy as it used to be. They changed the laws on us in October of 2018. Sorry, I'm getting a little parched doing all the talking. But they made it a lot more difficult to get eligible for this benefit. There are still options. It's just a little more challenging. It's not for everybody anymore. If you've got, over $600,000-700,000 of value minus the value of your house, this probably isn't for you. The aid and attendance benefit is the highest level. There's actually 3 levels of this benefit. Aid and attendance is the highest. And that's what you hear talk about most. Basically, you need to have require and be receiving assistance with 2 or more activities of daily living, things that involve taking care of yourself. If you need help with those, that help is considered a medical expense, and then you're eligible for this highest level of the benefit. To give you an idea, if you are a married veteran and you need this, you're looking at almost $30,000 a year that the VA will pay you to help offset some of the cost of the medical bills that you have. That's, you can see down here. The HB is housebound. That's a different benefit. That's a step down. Still good, but obviously the difference between those numbers is pretty great. Important to note here is if you're the surviving spouse of a veteran who meets the eligibility criteria, you can still be eligible for this benefit too. It's less, as you can see, but you could still get, in this case, over $15,000, almost $16,000 a year to help towards the cost of your medical expenses. So it's a pretty great benefit for those people who can qualify for it. We're happy to have you come in. You can meet with one of our team members. We can do an assessment to help determine whether or not you're eligible for this. And, sometimes what we do these days is there's a 3-year look back period now. So we'll use the Family Fortress Trust to get people eligible for this in 3 years. Take your stuff, put it into the trust, wait 3 years, then you can apply for the benefit. So if you see this is something that could be on the horizon, do the planning in advance, and it's much better than trying to do the planning later on. So now this is what I think a lot of you may have questions about or thoughts about, because we see this the most. This is when people are in nursing homes and they're looking at those big bills, over $100,000 a year. How do we pay for it? This is what helps. So again, there are tests in order to qualify. You need to have a level, what they call a level of care, but basically what this means is you need to be in a nursing home and you need to actually be there. If you just go strutting in and jump into a bed, Medicaid isn't going to pay for you to be there. You need to actually need the care in that facility. They look at your income. The income test gets adjusted every year. I'm honestly, because I'm not as involved with this part of the team anymore, I don't know what they've adjusted it to, because they normally adjust around the first of the year, but historically it was around $22.500 to $2,300. I'm sure it's right in that range still. And then the asset test is the really difficult one. If you're an individual, you can't have more than $2,000 in your name, which isn't really great. If you're married, your spouse can have about 130 in their name, but anything more than that, you run into problems. However, there are easy ways to get around all this stuff that we'll get into. And I say easy, we deal with it every day, but you get the concept. So let's talk about this type of Medicaid. There's actually multiple different types of Medicaid in the state of Florida. The first one is the Institutional Care Program. We call it ICP. I'm sure you can understand why. And basically it provides for room and board in a nursing home. It pays your Medicare Part B premium. It'll actually pay any co-pays for Medicare in general. So, the room and board in a nursing home will cost you $10,000 a month. They pay for that. Your Part B premium, I guess whatever, $120, $140 a month, they pay that. And then the beautiful thing is, if you ever end up in the donut hole or anything like that with your medications, they fill in all the co-pays and all of that. So it's a pretty neat program. But again, you actually need it. You need to be in that nursing home and be requiring that care. Medicaid waiver program is something that a lot of people have started to learn about and express interest in. It's contributes to the cost of either in-home care or care in an assisted living facility. Skilled nursing is the highest level of care. Assisted living is a step down. You have assisted living, group home, that sort of stuff. It's a step down as far as the level of need. Oftentimes these people are ambulatory, can get around on their own. They may need help, maybe showering or bathing or something, because of a fall risk or medication management. But generally these people are not bedbound and things of that nature. Oh yeah, and it contributes to adult daycare as well. I forgot that one. So if you have taken your parent to a place where they can be watched and taken care of while you're at work, the Medicaid waiver program will contribute to those fees as well. Now, unlike the ICP program, they don't just pay everything. They pay a contracted amount, and you're expected to make up the difference. So you could be in a place that costs $3,000 a month. Medicaid waiver pays $1,500. You're expected to make up the other $1,500. With the ICP program, Medicaid says just pay your income and we'll pay everything else. So if it's $10,000 a month and you're making $1,000 a month in Social Security, you pay that $1,000, Medicaid takes care of the difference. So it's a pretty great program from that perspective. Medicaid waiver is still good, but it's not going to provide you as much. The downside of the Medicaid waiver program is that there's a wait list associated with it. We just found out within the last couple of weeks that currently there are over 60,000 Floridians on that wait list. And it is not uncommon to be on that wait list for more than 6 months, sometimes up to a couple of years. So what do you do when you have too much stuff? You don't meet the eligibility guidelines. Well, if you're looking for, there's all kinds of stuff here. We can turn countable assets into exempt assets. We can convert assets into income. We can use personal care contracts to get things out of your name, pooled trust companies, and all sorts of other spend down strategies to basically make sure that whether you're over the income or the asset limit, we can deal with it in a way that renders you eligible for these benefits. So when you have a married couple, there's some pretty great strategies because transfers between spouses are not penalized. You may be familiar with this concept that there's a 5-year look back period for Medicaid, which means you can't give away money within 5 years of applying for Medicaid. But if you're giving money to your spouse, it's exempt from that. If you're giving money to a disabled child, this is exempt from that as well. I talked with you there, or I mentioned, there's income conversion strategies, so we can take a lump sum of money and turn it into income because income's kind of easier to deal with than the money side of things is. There are all kinds of ways that we can provide additional care for the spouse in the home. And then we can even, after we get people eligible, we can protect their eligibility through really tailored estate planning. So, oftentimes people come to us to get their wife eligible for Medicaid. Well, we get her eligible, but then there may be a lot of money in the husband's name. And we say, hey, if you don't update everything, God forbid you pass away before she does, now everything's going back to her. And we're going to have to do this whole plan all over again. So, by changing the estate planning, we can actually ensure that the planning we do on the front end to get people eligible for Medicaid is maintained, even if, the well spouse, if you want to call it that, ends up predeceasing the one in the facility. Just an example of a success story that we did. This was kind of a quirky one. Gentleman needed to go into Medicaid, into a skilled nursing facility, needed Medicaid, but he had too much money. His wife wanted to use the strategies that we oftentimes use where we move everything into the spouse's name. The problem here was that they had a prenuptial agreement. And so he didn't want her to have everything. He wanted stuff to go to his children. A lot of attorneys will just say, you know what, it's okay. We're just doing it for Medicaid. We'll get a confirmation from her that she's not going to not going to keep all the money or anything. But that can lead you until, kind of down a very dangerous path. What we ended up doing is getting the children involved. We got the Medicaid approved. We were able to protect the assets, and we did it while avoiding something terrible called tortious interference with an expected inheritance, which could have gotten the wife sued. It could have gotten us sued. But these are the types of things that, just a lot of people probably don't think about. Most lawyers, candidly, probably don't think about, is that when you're doing this type of planning, you really need to make sure that you're paying special care to the different unique situations that you run into. So before we go any further, I want to just give you kind of a little, word of caution. There are people out there who file Medicaid applications. They call themselves Medicaid planners. They're not regulated by anybody. They can't prepare legal documents. They can't even give you advice on how to qualify. Basically, all they can do is submit a Medicaid application for you. These people have no fiduciary duty to you or anything like that. When things go wrong, they just walk away. By working with an elder law attorney, you are protected in that, we have a fiduciary obligation to do what's in your best interest. And we see these things through to the end. In some cases, we've had to appeal. So, sometimes the department, they're kind of like a revolving door there, the Medicaid offices, and they'll get people in who don't know what they're doing, and they'll deny cases that they should approve. Well, they have a way of dealing with that, a hearing system where we go in front of a judge and we present our evidence to show that it should be approved, and then the judge makes the decision, which is normally to approve it. We always go and do those hearings. We've had one hearing where the judge had an off day, and we had to actually appeal it to the 5th District Court of Appeals here in Orlando. We did that and won it there. So, we have the obligation to continue to go through this stuff and see it all the way through to the end, where when you deal with these other people, they can kind of walk away at any point and say, well, we tried, did everything we could, too bad. We just keep going and going and going until we get it done. Obviously we can prepare the necessary documents, advise on the appropriate strategies. I mean, we submit the applications as well, but there's a great, ocean of difference between what lawyers can do and what the non-lawyers can do. So kind of what makes us different when you work with our firm anyways, is everything is a flat fee that's agreed to in advance. We don't bill hourly for anything. So, you don't have to worry about, writing us a blank check where lots of lawyers say, oh, I bill $300 an hour and we'll see how many hours it takes me. That's silly. I feel like that encourages people to kind of work longer, not smarter. So everything we do is agreed to in advance. A full third of my staff is bilingual in Spanish, native Spanish speakers. So it's very easy for us to help people who, maybe English isn't their first language. And then, as you can see on the right, we win lots of awards for having a real, I guess I would say unparalleled. Yeah, it's already written there. I was going to use something else, but I guess I'll stick with that. An unparalleled client experience. We work really hard to give clients a really great experience at our office. We return phone calls, we answer phone calls, do all those types of things that a lot of attorneys don't. So just some takeaways before we close this, because again, I'm trying to keep things moving. I would be really cautious of hearing, taking advice from people who aren't lawyers. Oh, my neighbor said, oh, when we did this for my mom, who lives in Arkansas, well, we did X. You got to be careful, because these laws change regularly and you don't know what that other person's situation looked like. In a previous life, I did divorce work, and someone say, oh, well, my neighbor got divorced and they got X, Y, and Z. I'm like, well, the facts of your case are very different than the facts of their case. You can't compare these sorts of things, and you can't do it with Medicaid or any of this sort of planning either. What is good for one person, or what is right or appropriate, or for one person may not be appropriate for somebody else. And so there's lots of different strategies that we have to look at. There's a lot of misinformation out there. People try to do this stuff on the internet. I always tell them it's like going to WebMD instead of going to your doctor. Chances are you probably won't get it right. Even if you do, it's probably going to hurt a lot until you get it figured out. There's a lot of misinformation on the internet. I encourage people to really just talk to somebody who specializes in this stuff. I mean, we live in an age of specialization. You don't go to your podiatrist to get your lungs checked out, or your neurologist to have your heart, checkup done. We encourage you to go to people who specialize in this sort of stuff. And then just know you don't have to freak out, feel helpless, like, there's no options, because there are. It doesn't matter if let's say your dad has been in the nursing home for a year and he's been spending down his money and he's only got 100,000 left and it's going to be gone at the end of this year. It's not too late. There's still stuff we can do to protect that and still get him eligible for benefits that can help. So I'd like to open it up now and see if you guys have any questions. I don't want to take too long, because I know we've kept it pretty long as it is. But if you do have, questions you don't want to ask here, feel free to reach out to us via phone or email. If you have kind of, personal sorts of questions you don't feel comfortable asking in front of other people. But in the meantime, if we have any questions here, I'd be happy to take them.
Yes, we have two questions, and Nancy, go ahead with your question.
Yes, I wrote them on the chat. When you talk about the premarital children, you mentioned that the Florida statutes, when they go to probation, designates like half for the children and half for the spouse. My question is if that includes the main residence.
So yes-ish. That was a little bit of a unique, it can. So here's the deal. Our homestead laws in Florida are very unique, and they're designed to protect spouses. So what the statute says is that if you're married and you pass away, your spouse has what's called a life estate in that property, meaning they have the right to live there until they pass away. And then when they pass away, your will decides where that, or the Florida statutes decides where that home goes. Now, the caveat here is this assumes that the house is not jointly titled. If the house is jointly titled, that house is going to the spouse in full when the first person passes away. So, you know, let's use an example here. Say the house was in the wife's name and the husband only, and she passes away. The husband would have the right to live there until he passes away. And then when he passes away, the home goes to the kids. Now, the caveat there is he has the right to claim what's called a spousal elective share, but in the homestead, which basically gives him half of the value of the home. So he would own that home instead of a life estate. He would own half that home right then, and her kids would own the other half. And then they would probably sell it, and he would take half the proceeds and the kids would take the other half. But
Okay.
if the property is owned by two people, when the first person dies, the second one owns it entirely and the children don't come into it at all.
Okay, thank you. And the other question is, do you know an attorney who specializes in this same type of law in the state of Tennessee, or can you take a case for Tennessee residents?
Yeah, so I'm not going to do anything for Tennessee residents. I'm only licensed to practice in Florida. I'm trying to think of someone offhand that I may know that practices in Tennessee. What area of Tennessee?
Northwest, northeast.
Okay.
Very northeast.
Okay.
So Kentucky area, more to the east.
Okay. So I'm not sure
Um,
of anybody in that area. What I could probably do is I'll type it into the chat here. My recommendation would be to look for an attorney who is a member of that organization, the National Academy of Elder Law Attorneys. We call it NALA. But if you can, go on their website and put in an area code, and they'll put you anybody. They'll it'll tell you who's in that area, and those tend to be some of the best lawyers who are really focused on this type of practice.
you said National Academy of
Elder Law Attorneys. I typed it in the chat. If you can open your chat, it's NAELA.